struck by was how uneventful some of them were. I mean, they really were an application of established law to new and sometimes different facts. But what we weren't seeing were these bold innovations in the law that we would see in opinions even 5 years ago, because it was still such a new field at that point that everything was a question of first impression. And so the judges were really forced to make analogies from the Nuremberg law, draw from domestic law, both civil systems and common law systems, and try and come up with what would be the best rule for the international criminal justice system going forward. And so the opinions were incredibly innovative. And there were lots of calls by defendants that there were ex post facto problems, right? We were applying new law to facts at the time that I could have never known that my conduct would have been considered criminal, for example. We're not seeing those sorts of arguments anymore. And I think in many respects, this trend marks a maturing field of law. We're no longer making these bold innovations. We're really just tinkering with the doctrine at the edges. And I think that's a great thing. We now have a truly international criminal justice system. Now, the ICC has not yet issued a final judgment. There's been lots of interim rulings. So it will be interesting to see to what extent the ICC charts its own path, or will we see more and more citations from the other ad hoc tribunals that came before the ICC? The ICC has been very clear to say we're not bound by any of those rulings as a matter of precedent. Obviously, they are helpful and very persuasive authority, but all of the personnel, from the prosecutor's office to the defense to the judges, have made very clear that they're going to chart their own path. And so it'll be interesting to see as those opinions start to come down, as the early cases come to an end, to what extent we start to see new innovations given the statute there. Where the law has been relatively stable, we're actually now in a situation of real institutional flux. So the ad hoc tribunals are starting to shut down, as you've gathered. They are the subject of completion strategies, and I'll talk a little bit about what that means. Meanwhile, the Special Tribunal for Lebanon is finally gearing up. They've issued their first indictments, and we're sort of on the verge of either moving forward without the defendants or waiting to see whether or not we'll ever get custody over some or all of the defendants. The ICC has yet to issue its first judgment, but it's going to undergo a huge overhaul in its professional staff, which I'll talk about. And finally, it's fair to say, is in a state of real political crisis. And that, again, may have been implicit in the comments yesterday, but I'll try and give you some of the backstory there. So why don't we get started with the first slide? So this is the International Criminal Court. It's really the flagship institution for the international criminal justice system. Last year's Chautauqua lectures focused on the crime of aggression, which had just been codified that summer in Kampala at a review conference. Interestingly, so far, no states have ratified the new amendments, even though 5 states have joined the court since the review conference. So it remains to be seen whether or not the states are going to line up behind those amendments. We need 30 states to ratify the amendments for them to be ready to be activated. There's lots of sort of steps along the way before the crime of aggression can be prosecuted. So at the moment, that crime is sort of lying dormant within the statute. The amendments are quite complex. There are a number of jurisdictional loopholes in them. The crime itself is very controversial. States made strong statements in favor of it, but it's not clear how rhetorical they were, if that support that was expressed at the review conference is shared back in the capitals of those states. And so again, it remains to be seen to what extent those amendments will be ready to be used in 2017, which is the earliest that they could be voted into activation. The big news institution-wide at the ICC is the staff turnover. 6 judgeships, the chief prosecutor position, and the presidency of the ASP, Assembly of State Parties, are all up for grabs. And this will be the biggest overhaul of the staff since the court's conception. And it's really unfortunate in a way that this is the statute created this turnover to happen all at once. But literally, these events are happening as we speak. Starting with the prosecutor position, the chief prosecutor, they have created essentially a committee to accept statements of interest from potential new chief prosecutors. And the front runner is someone who we've met and had the opportunity to spend some time with, Dr. Beth Van Schaack, who's now the deputy prosecutor. Other candidates in play have been, of course, everyone else that is sitting at this table and others who are here, former chief prosecutors and current chief prosecutors of the other tribunals. Interestingly, one of the most obvious candidates would have been Hassan Jalloh, who's the chief prosecutor of the Rwanda tribunal. He, however, is barred from the position so long as Fatou is the deputy prosecutor. I've got the text here, but one of the requirements is the deputy and chief not be of the same nationality, and both of them are from the Gambia. Who knew that the Gambia was such a font of fabulous international criminal law jurists, but as it turns out, that's indeed the case. So he has withdrawn, he's not in formal considerations for that role. It will be difficult for some of the other chief prosecutors to leave their institutions at this point. As we'll talk about, there's been some really exciting and important developments there. It's really the swan song period of those tribunals. There's lots of important defendants that the courts now have jurisdiction over, they have custody of, and so it may be difficult for these individuals to leave their institutions at this particular moment in time. So that has opened up for consideration of other jurists, individuals who are members of the international community, the human rights community, some of the human rights institutions, to put their names forward. To date, we do not have that list. It will be released sometime in the next couple of weeks, so you can keep your eyes open for that. Judgeships. There are 6 judgeships now open. This is also the subject of an ongoing process whereby states can nominate their nationals. And you have to be a member of the court in order to be able to nominate someone for a judgeship. So we have a search committee. And there's some really troubling and worrisome developments in this process. Number one, the court is supposed to have individuals on the bench who have either criminal law experience or law/human rights experience. And they sort of are considered into 2 camps, and they want to keep a kind of an equal balance between those camps. Almost everybody who's now on the list, 9 of the 10, have criminal law experience. There's only one person who can really credibly claim to have humanitarian law or human rights experience. Also on the diversity front, there are no women on this list, as may be obvious from the names. The statute mandates that there be a fair representation of both men and women on the bench. We've got a great representation at the moment, but 3 of the 6 who are now having to step down are women, and no women have been put forward yet. The nomination period is still open, and so there's some rumors that the Philippines and others may have candidates percolating there, but we're still waiting to see who those final names will be. We also have concerns about the process by which the judges will be chosen. Of course, many people in the field are hopeful that it will be a meritorious decision based upon the individual's qualifications, etc. What we know about the international system is often this is a very cynical case of vote trading, right? We will support your candidate for the ICC if you support our initiative here, or our candidate for this position, or etc. And so there is this sort of sense that that kind of a process may take over, and that would obviously be very unfortunate. As Professor Amen mentioned in her talk last night, really at the end of her talk, and the punchline was, it's important to get good people in these positions, and that will not happen if we do this by virtue of vote trading. It really has to be based on the merits. Africa and Europe are well represented in terms of candidates. Asia has not put forward a candidate, and so if the Philippines does so, that will be an important development. Also up for grabs is the head of the Assembly of the States Parties, which is the political body of states that have all joined the court. So, for example, the United States is the only observer at the ASP because we've not joined the court, although we have signed the treaty. And the bureau, which is the sort of, political body, within the political body, has nominated this gal, Tina Intelman, who's the Estonian ambassador. She would be the first woman to run the ASP. She would be taking over from Christian Wetterracer, who was from Liechtenstein and actually had a very, very strong tenure as head of the ASP. He was in charge of the aggression negotiations, etc. And so she's likely to be the individual who would take over that position. So turning to our situations, this is a map that shows the active situations, except one. Wikipedia has let us down. Libya should also be in red, and I checked as of Sunday as I was getting the plane, and it still had not updated it yet. I don't know how to do that. So if any of you know how to get into Wikipedia and mess with these things, you can add Libya to the list. Obviously, the first thing is that they're all in Africa, which is partly why both Fatou Bensouda and Hassan Jalloh were really considered sort of front runners for the position of chief prosecutor, because all the situations do come from Africa. And this has created some tension within the African Union, which is the political body of all African states. From the beginning, the African Union was very supportive of the court. Something like 31 of 53 states in Africa have joined the court. They've been very active in the review conferences. But with the indictment of President al-Bashir of Sudan, that soured the relationship with the AU, and the AU has made some formal statements calling upon member states not to cooperate with the court, notwithstanding that by virtue of joining the court, there is a pledge of state cooperation in the treaty, so that all states have pledged to cooperate. And so there's a real tension between the AU formal position that has been taken and what treaty obligations exist. In addition, there are UN Charter obligations. Because the Sudan situation was forwarded to the court by the Security Council as the sort of executive body of the United Nations, all states are obliged to cooperate with and to implement decisions of the Security Council. Now, the AU does not speak with one voice in this regard. There are individual member states like Botswana, etc., who have come out in support of the situations that are now pending before the court. And so there's a real internal struggle happening within the AU. So there are three ways in which situations can come before the court. A state can refer a situation, the Security Council can refer a situation, and the prosecutor, acting on his or her own determination, can initiate an investigation, having to go through a sort of a hurdle of the pretrial chamber. And as this chart shows, 3 of the 6 situations were state referrals. Now, what's interesting about this is when that was designed back in Rome, the vision was that one state would refer another state, for example, a neighbor state where atrocities were happening, or a Good Samaritan state where the European states would refer one of the, an African state or a Latin American state where there was an internal conflict happening. And what has been surprising to many is that the way in which the state referral mechanism has been used is that states have actually referred themselves. So all 3 of these situations are so-called self-referrals, where Uganda, the Democratic Republic of Congo, and the Central African Republic have said, we can't handle the justice implications of the atrocities happening in our midst. We need help. We want to refer the situation to the court. It was somewhat controversial. The court has just breezed over that and just accepted those situations and is hearing those cases. The Security Council has referred 2 cases, as you see, and the prosecutor has initiated 1 case. So, turning to the most recent referral, it's been in the news most recently, is the Libyan referral. It's obviously highly contentious. It was referred unanimously by the Security Council. Ocampo, who's the lead prosecutor, requested 3 arrest warrants. Interestingly, the crime that's been charged is crimes against humanity and not war crimes. And the theme for this year is crimes against humanity, and I think that really demonstrates the utility of that charge in international criminal law, because you don't have to worry about is there armed conflict or not? Have you crossed the threshold? Who are the parties? Is it an internal conflict, an international? You dodge all of that difficult doctrinal work, and the only threshold question is there a widespread or systematic attack against a civilian population? And of course, that's easily satisfied in Libya. And so that's why that charge has been pursued. At the arrest warrant stage, the standard is, are there reasonable grounds to believe the individual committed the crime? And as we go forward, that standard of proof on the prosecutor rises until we reach the beyond a reasonable doubt standard, which is what's applicable at trial. So it's a relatively easy hurdle at this stage. And in fact, it has been deemed that there are reasonable grounds. The theory of the case is that there was a state policy to quell this uprising that was happening that we saw across the entire Arab Spring, using violence and the state security apparatus to do so. And with Gaddafi's indictment, he becomes now the 6th head of state. So he joins Jean Kambanda of Rwanda, who was prosecuted by the Rwanda Tribunal, Charles Taylor of Liberia, who was prosecuted by the Sierra Leone Tribunal, Slobodan Milosevic, prosecuted by the Yugoslavia Tribunal, President al-Bashir, who's under indictment from the ICC, and Karl Jonas. Everybody forgets about him, but when Hitler committed suicide, for 23 days he was the successor, and he was one of the number of defendants. And so we now have a fairly consistent practice of abrogating any sort of a head of state immunity when you're in front of an international tribunal, and those cases are going forward. One of the key defendants here is Gaddafi's son, who's considered one of the most influential members of his inner circle. He holds, however, no formal government position, which is quite interesting. And so the theory of liability is that he had de facto power within this, this inner circle of Gaddafi to implement this repressive regime. There were allegations that he had been taken into custody and the transitional government was in conversation with the ICC. These conversations were made public, creating an enormous embarrassment when in fact it turned out he was no longer in custody. It's not exactly clear what happened, but there may have been some sort of an inside job that enabled him to be released. And so that has been a major setback in terms of this indictment. Now, an interesting little factoid of concurrent jurisdiction. There is an Africa-wide court of human rights that has also asserted jurisdiction over the situation in Libya. And that court has essentially said to Libya, it's issued an injunction, we can make that analogy to the domestic system, stop repressing your citizens, stop attacking innocent civilians. Of course, the Libyan government ignored that. But we have this interesting now situation where we have this concurrent jurisdiction. The ICC exercising individual criminal responsibility over identified individuals, and the African Court of Human and People's Rights exercising state responsibility, applying state responsibility to the entity that is Libya. And so these are happening now in parallel. So thinking a little bit about Darfur, this is an interesting case, and I think Fatou Bensouda was a little sensitive to this, about the symmetrical indictments. So we've indicted both sides. We've got government indictments, and we've also got rebel indictments. Interestingly, all three rebels who were under indictment voluntarily turned themselves into the ICC. This was an incredible development, and really a statement about the fact that they believed that they could exonerate themselves before the court. One of the individuals managed to fight the confirmation of his indictment, so that indictment was actually dismissed against him. The prosecutor could conduct an additional investigation and recharge him, but at the moment he's back free man. This is Abu The other two are now before the court. And the incident involved is this attack on African Union and international peacekeepers. All of the government individuals who have been under indictment and a leader of the Janjaweed, which is this sort of shadowy paramilitary force that is working in conjunction with the government forces, they remain at large. And al-Bashir, of course, has traveled, and he's traveled to ICC member states, Kenya and Chad, who, as I mentioned earlier, should have immediately taken custody of him and handed him over. And so we're still in this situation of the court is not necessarily enjoying full cooperation from its members because it does not have an internal police force that all Interpol can do. So if you think about Interpol, it's amazing. Now, they issue an international arrest warrant, they coordinate that. That's it. They don't send people out necessarily. And so that's the situation we're in now. Next situation, Kenya. This one is interesting in that this was initiated by the prosecutor after a very long diplomatic dance with the authorities in Kenya, where the Kenyan authorities said, no, we're going to create a special tribunal, we're going to take on the obligation of prosecuting post-election violence, let us handle it, look, we've got this legislation. Well, what ultimately happened is that legislation continued to stall in the parliament. The quorum would never be there whenever the legislation came up for a vote. And so, time after time, no real forward progress was made beyond that, just the conceptual idea. And so finally, the office of the prosecutor said, we're going to move forward, and they did, in fact, move forward. Again, crimes against humanity have been charged. Persecution, deportation, rape, forcible transfer. There was not the threshold for an armed conflict during that post-election violence. And so again, a utility of crimes against humanity charge. Kenya is now actively fighting this case, and I've put on there Article 17, which embodies this idea of complementarity. The ICC is meant to stay its hand in the event that a national system, either the nationality state or the territorial state or some third state, is credibly moving forward with prosecutions. And what Kenya has argued is, we've done enough. We've done a number of constitutional reforms, we've done a number of judicial reforms, we've created an ombudsman, we've created an independent prosecutor position, we are going forward with investigations. ICC should stand down. And what so far the prosecutor and the ICC have both reasoned is what we need to see is that the actual individuals whom we're targeting are the subject of domestic prosecutions. And you can't, frankly, show that yet, can you? You can show investigations, you can show intent to investigate, you can show maybe even individuals of the same level being investigated, but these 6 are not being investigated. And so until that happens, we're moving forward. Again, it's a symmetrical indictment. We have 3 and 3, both from the opposing political parties, appeasing concerns that the court is one-sided necessarily, but it remains to be seen whether the facts will bear that out about whether responsibility is equal. So, parallel with the work of the ICC often is other transitional justice mechanisms. So in Kenya, what we see is a Truth, Justice, and Reconciliation Commission. Its mandate, it's important to remember that the ICC is often situated within a much larger transitional justice agenda of a country that is emerging from a period of armed conflict or of repression against civilians. And so this mechanism has a much broader mandate. The ICC is very much limited to the post-election violence. The Truth Commission has adopted a much broader mandate that says we are going to look at the allocation of land, we're going to look at ethnic violence, we're going to look at political patronage since independence, on the theory that the post-election violence was really the tip of the iceberg, and that the roots of that were, I'm using my metaphors, but the roots of that violence were planted much, much earlier, and so it would be artificial just to focus on that, flash in the pan that happened after the elections. And so they've taken this much broader mandate. They also have a lot more activities they can do. They can hear testimony from victims, from witnesses. They can think about reparations. They can make recommendations for structural reform within the country. So they have a very broad mandate. Unfortunately, the institution was plagued by conflicts of interest in the early days. It turned out that the chair of the commission was potentially a recipient witness in one of the key cases that the commission was going to be looking at, and also may have benefited from some of the land transfers that happened after independence. He refused to step down. He claimed he was innocent and that he could do his job. He refused to step down. It brought the commission to a standstill. There's one American on the commission. The only non-African on the commission is Professor Ron Sly from Seattle University. He threatened to step down if the chair did not step down, or the other commissioners did in fact step down. The chair finally did step down, so now the commission is sort of running full force ahead. They're in the field, they're hearing testimony, and they're working on writing a sort of definitive report about the way in which some of the post-independence decisions actually laid the groundwork for the conflagration that happened after the elections. So, turning to Uganda, there's unfortunately not a lot to report. The Lord's Resistance Army defendants are still at large. They're reputedly now wreaking havoc in the DRC and maybe in the Central African Republic as well. So we're hopeful that some of these new initiatives, the satellite imagery, the on-the-ground work, will eventually flush them out and get them in front of the tribunal. There is a sense that the Lord's Resistance Army is an army that, if decapitated, will simply dissipate. They will not simply replace him. He is such a messianic figure that if Joseph Kony can be captured, there is a sense that would neutralize the Lord's Resistance Army. So we're hopeful in that regard. One important development is that Thomas Koyelo, who was a commander of the Lord's Resistance Army, has been taken into custody. Uganda has created a special set of sort of international crimes division within its domestic system in order to enable the prosecution not only of Lord's Resistance Army individuals, but also, it is hoped, Ugandan People's Defense Forces, the Ugandan forces, who also have been accused of committing atrocities in the field. And so the hope is that there will be some equality there of prosecutions going forward. This is a new development, so it's something to keep our eyes on. The DRC has been the most active situation. We have individuals in custody. There are cases moving forward. The parties have put the Lubanga case actually to the judges. That would be the first substantive judgment that will be issued. A little interesting development is some individuals who have testified on behalf of the defendants actually applied for political asylum while they were in the Netherlands. And this has created a little bit of a political crisis that had never been done before. And so the question was, what was the obligation of the court to respect that right of individuals to apply for the for asylum. They had an agreement with the DRC that these individuals would not have outside contact while they were testifying, but they were able to get before the Dutch authorities and put through Dutch lawyers and put their asylum applications in. The court has said, we think it's safe to return these individuals, that they will not fear persecution if they were to return home. But, says the court, we recognize that this is ultimately a decision of the Dutch government. So those asylum proceedings are moving forward. The main charge in a lot of these cases is this idea of recruiting and using children, child soldiers, in conflict. And there's been some very interesting counter evidence that has been churned up by the defense. Individuals saying, listen, the data that you have from this region on child soldiers comes primarily from demobilization centers, where child soldiers come forward, they turn in their weapon, they get a kit of materials, they get some rehabilitation, etc., and then they're brought back to their home communities. And a non-governmental organization working with child soldiers has conceded that basically the word got out that if you walked into one of these centers and you said you were a child soldier, you get a great little kit with a blanket and this and that, and you get some food and you get clothing. So, there's some contestation about how many child soldiers were being used, and it will be very interesting to see what the court says in terms of what their ultimate findings are. The Central African Republic, the one individual here is Jean-Pierre Bemba, who actually is a citizen of the DRC, although he's accused of leading a militia that had been brought into the CAR to quell insurrection there by a former president. And the situation here is really characterized by gender-based violence, which is one of the reasons why having experts on gender-based violence at the court is really important. All of the situations involve claims and allegations of gender-based violence. A little quirky development with regard to Bemba is he's planning on running for president in the CAR. He's applied for pretrial release a number of times. He has never been granted. And he has made the argument that he can in fact run from his cell in The Hague. And so there's a number of sort of, that's obviously being contested. There are some lawyers in the CAR that said actually you have to be physically present in order to be able to run for president. But he's certainly squeezed out other potential candidates from his political party. And so we'll have to see whether that's going to go forward. Something to keep in mind is Côte d'Ivoire. This was mentioned. The court has two jurisdictional preconditions. It can only hear matters, if it doesn't have a Security Council referral, it can only hear matters if the territorial state is a member or if the state and nationality of the accused is the member. So you've either got to have the territorial state or the nationality state. The Security Council can override either of those, and that's why we can have Sudan and Libya, neither of which is a party, actually before the court, because the Security Council has the power to override these two jurisdictional preconditions. But the drafters of the statute were clever in that they created a mechanism for an ad hoc acceptance of jurisdiction, where a state could say, with respect to this crime, and we don't know what that means, how broadly this crime is going to be defined, we accept the jurisdiction of the court. And Côte d'Ivoire has done one of these ad hoc declarations with respect to their post-election violence. If you remember, President Gbagbo refused to accept the outcome of the election, and it caused a number of there were clashes all over the country between he and his political opposition. That ad hoc referral has been reaffirmed now by President Ouattara, and so the court is moving forward with investigating. The New York Times just reported that there have been 12 indictments issued. And so this has triggered this question of complementarity. Is Côte d'Ivoire doing enough that the ICC should stand down, or are those indictments not parallel to what indictments would be brought for the ICC? I've heard, although I haven't seen these indictments, that they tend to focus more on corruption crimes and not on crimes of violence. And so it may be that there's room for concurrent jurisdiction here. And so this will be another situation to watch. The only other Article 12.3 ad hoc declaration that has been made is by the Palestinian territories. And as Fatou Bensouda mentioned, that is still under consideration. There's very complex jurisdictional questions about whether the Palestinian territories constitute enough of a state in which to have the ability to refer itself to the ICC. And that's been under consideration for more than a year now. So, closing out the ICC, just focusing a little bit on the ICTY, which is under a Security Council mandated completion strategy. And what this is going to involve is the creation of a residual mechanism, which will be essentially a roster of judges that will be deployed when necessary to sort of do cleanup, essentially, on some of the cases. So the ICT-1 will continue with a limited staff on the current cases, the high-level cases. Lower cases were meant to be transferred back to national authorities. Those transfers have happened. And then this residual mechanism will handle sort of ongoing things that come up, such as new evidence and review questions, motions to review judgments based upon evidence. Contempt proceedings, right? Proceedings where they're involving interference in the process of justice. Parole questions. These will all be dealt with by this residual mechanism. It will not be empowered to issue new substantive indictments involving former Yugoslavia, but it will be able to issue, for example, contempt indictments if there are allegations of witness tampering or retaliation against witnesses. The big news of the ICTY, and this is an incredibly important development in the international criminal justice movement, is that now every individual under indictment is in custody. And with the capture of these last two individuals, that sort of, crossed the last people off the list. So Mladic, we'll hear a little bit about at lunch today. He was the second in command behind President Radovan, quote-unquote, President Radovan Karadzic of the Republika Srpska, a self-proclaimed Serbian entity within Bosnia and Herzegovina. And then Goran Hadžić, who is charged with ethnically cleansing the Krajina region between Bosnia. It was a Serbian, there were a number of Serbian individuals living there, but it was at the border of Croatia. And he is alleged to have cleansed that area. So that's what that indictment concerns. Another case I want to just mention is this case against Gotovina, which is in many respects the inverse of the Hadžić case. So Hadžić is accused of cleansing the area of Croat residents in order to create this Serbian enclave. Gotovina is accused 4 years later of re-cleansing the area of Serbian inhabitants who had moved in after the Hadžić cleanse. Now, what's interesting about this case is Gotovina received a lot of support from the United States in implementing what was called Operation Storm, which was billed as an effort to reassert constitutional control over the Krajina region and essentially take it away from the self-proclaimed Serbian political entity. He had assistance of drones, he had targeting assistance, he had certainly training, weapons assistance. The full extent of the United States involvement is not fully known, but it's very clear that we had a real interest in him not only succeeding, but doing it in a way that was completely clean under the laws of war. And in fact, the tribunal found that 95% of the targets that were the subject of Operation Storm were in fact military objectives and that proportionate and appropriate amounts of force were utilized. Nonetheless, with respect to these other sort of 5% of areas where there was artillery used, the court concluded that civilians were purposely targeted through the implementation of Operation Storm. And that ruling then serves as the sort of foundation for a number of other rulings. So Operation Storm coincided with a massive exodus of the Serb populations of the region. And the question is there causality here, right? Were individuals being targeted such that they left, in which case we charge the crime of deportation through an unlawful attack against civilians? Or did they leave prior to Operation Storm because they didn't want to have they wanted to avoid an armed conflict, they didn't want to deal with Croatian authorities moving in? It's very unclear the timing and the evidence of this, of the way things kind of went down in these short periods, a 2-day operation. The trial chamber has convicted on the basis of a finding that Gotovina, was part of a joint criminal enterprise to purposely target civilians. And all the other findings of criminal liability hinge on that finding. So my sense is that this is ripe for appeal, and it would be very interesting going forward to see how an appeal ends up playing out. There's another interesting case here, just as more of a legal point that just might be of interest given the way in which we've structured the system. In the U.S. system, we have 3 tiers of appeal. We have a district court, a lower court, a court of appeals, and then we have ultimate authority of the Supreme Court. In our systems in international criminal justice, there's usually only 2 levels. So this individual, Silvančićin, mispronouncing his name, I'm sure, was convicted by the trial chamber, the lower chamber, involving an incident in which a hospital in Vukovar, all of the patients were taken out of that hospital, taken to a detention center, mistreated, and then executed. And he was charged under a command responsibility theory of soldiers under his command of the Yugoslav National Army participating in that. The trial chamber found that he couldn't be held responsible for the murders of these individuals. He could be held responsible for the mistreatment because he knew that his troops were there, he knew that there were many paramilitaries working there as well who had been associated with abuses in the past, and he failed to prevent the harm or to punish it after the fact. The appeals chamber actually reversed the acquittal on the murder charges and imposed a murder conviction. So on appeal, his sentence was actually increased from 5 to 17 years. In 2010, he applied for review of that judgment by the appeals chamber on the theory that there was new evidence that he didn't know that his troops were not going to be there and that there would be paramilitaries there. And on appeal, the appeals chamber, looking at this anew, in light of this new evidence, said in fact the conviction for the murder charge was a miscarriage of justice, and so it reversed itself. Now, what's somewhat controversial about this is this idea of the appeals chamber being able to enter a conviction, and he has no right of appeal from that conviction. And this judge, Judge Chautauqua.charles from Italy, has consistently dissented from this practice of the ad hoc tribunals on the theory that all of the omnibus international human rights treaties protect a right of appeal of individuals who are subject to conviction. And when the appeals chamber enters that conviction, there's nowhere to go. There's no higher court to seek appeal from. And so he's constantly said, actually, what should happen is we should remand, send it back to the lower court, let them enter with our instructions, essentially, and let them enter the conviction. So we may have had a sort of clarification here, a fix here, that this possibility of infringements on the right of appeal remains very real. So, switching to Rwanda, the Rwanda tribunal has been very busy. They issued 6 trial chamber judgments, and if you've ever looked at one of these judgments, you'll know that they can run to the thousands of footnotes, and so issuing a judgment is a big deal for one of these tribunals. They also heard 3 appeals. All of the trial chamber judgments are under appeal, and so the appeals chamber is going to be very busy moving forward. Just some highlights. Military 2, which is one of these joint trials. This is part of the completion strategy, is to not try individuals, but if there's a thematic or a geographic connection between defendants, to prosecute them together. This has raised some fairness issues of accused that the tribunal was not empowered to take a guilty plea the way that we do, that just sort of ends the proceeding, you enter a sentence. The tribunal insisted on going through a process of hearing evidence, notwithstanding essentially a guilty plea. At the very last moment, the closing arguments, a couple of us, David was there, I was there, we had a stunning manifestation of the problems of this hybrid structure. The International Defense Council went first, reiterated this defense, asked for forgiveness, pointed out the ways in which Doig had participated, had given evidence, had helped the prosecution, laid the groundwork for future cases, yada, yada, yada. His Cambodian counterpart stands up and essentially completely changes the strategy, attacks the jurisdiction of the court, attacks every single charge, asserts the innocence of the defendant, demands an acquittal. Everybody was just stunned, and nobody knew what to do. The tribunal was talking to itself, they went back and forth. Finally, the presiding judge asked Doig to say, which is it? Are you accepting responsibility and asking for forgiveness and expressing your remorse, or are you demanding your acquittal and a finding of not guilty? And he ultimately sided with his Cambodian lawyer, and so he said, I want to fight the charges. His international lawyer stepped down at that point, and so the sentence was actually given of 30 years, essentially, which now he has appealed on the ground that it's too long and it doesn't reflect the degree of remorse and participation in the tribunal, so I think he maybe realized that there was a strategic error there. The prosecution has also appealed, saying that undue weight was given to so-called mitigating factors and that he should have what is in essence a life sentence, if only for symbolic reasons. He's in his 70s, so 30-year sentence is essentially a life sentence. And interestingly, the civil parties, the victims, have also appealed. And they asked for a broad range of reparations from the tribunal. And essentially all they got was their names listed within the judgment. They asked for memorials, they asked for psychological and medical assistance, they asked for a whole range of symbolic reparations, which of course Duik himself is not in a position to provide. And so really it would have been a recommendation on the part of the tribunal for what the Cambodian government should do. The tribunal took a very conservative approach, basically saying, listen, there's no money, he's indigent, so what we're going to give you is sort of acknowledgement in the judgment. They said that that's not enough, and so that's the basis of their appeal. Case 2 is the case that's now teeing up. It's the case against the surviving regime leaders of the Khmer Rouge. And we again heard a little bit about this. There are health concerns. Probably the case will not go forward against Yang Tarif. That was sort of the first I heard about that. The hearing was held yesterday. I saw her in her initial appearance, and she couldn't remember the number of children she had, etc. There was some concern that she was putting on an act, but she also looks quite frail. There's no question about that. And so, whether her case will be severed and the other cases will go forward is probably what will end up happening. Where the real controversy lies is with respect to cases 3 and 4. The ECCC, jurisdictional, in terms of personal jurisdiction, it says those most responsible. The leaders of the Khmer Rouge can quote those most responsible. And the question is, how far down a hierarchy do you go to be considered the most responsible? Case 3 involves the former heads of the Army, the Navy and the Air Force. They are both going to be the subject, if case 3 goes forward, of prosecution. And case 4 involves mid-level Khmer Rouge cadre, like this woman, Yang Cheng, who was in charge of a massive irrigation project, and also in her region, a detention center in which upwards of 40,000 people may have passed through and been executed in her center. The legal argument that has been made is that these people are not the, quote, most responsible, that we should stop at the regime leaders and at someone like Duik, who was very symbolically head of the sort of apex of the detention center. The international co-prosecutor, Robert Petit, who preceded Andrew Cayley, wanted to move forward with both cases 3 and 4. His Cambodian counterpart disagreed. There was an internal split between the two of them. Those sorts of splits were to be put to the tribunal. The tribunal said they can go forward, and so those cases went forward. They went to the co-investigating judges. And the question then was, what would they do? If you want to show the next slide. The co-investigating judges are there to the left. And one thing that was always said about this tribunal is, given this weird hybrid structure, it would only be as strong as the weakest international member, because you need an international member to agree on any decision of the tribunal. And the co-investigating judges did what many had charged as a very perfunctory investigation into both 3 and 4. They didn't interview witnesses, they maybe didn't even interview the potential defendants, they didn't do much work at all, and it caused individuals from those offices to actually leave their jobs. As an American, she's the lead prosecutor, and her theory of the case has essentially been that although he was in Liberia the whole time, and the Special Court of Sierra Leone only has jurisdiction over crimes committed in Sierra Leone, that nonetheless, he was controlling the Revolutionary United Front, which was one of the rebel groups in Sierra Leone, in order to get access to the great mineral wealth that is in Sierra Leone. That's her theory, that he was part of this joint criminal enterprise, which is like essentially a conspiracy. There's some doctrinal differences, but it's, it looks like a duck, sounds like a duck, it is a duck. It's essentially a conspiracy theory with these rebel groups. Courtney Griffiths, who's a Jamaican lawyer, who's the lead defense counsel, has put on evidence to the effect that there were huge disparate arguments between these factions. There were a number of factions operating in Sierra Leone, and that you can't allege a conspiracy amongst factions who are essentially fighting each other. And so that Charles Taylor cannot be held responsible for what these various factions were doing within Sierra Leone. He's also argued that even if there was a joint criminal enterprise or a conspiracy as between these various factions to get access to mineral wealth, etc., that he did not make any substantial enough contribution to that maybe he was sort of vaguely supportive, et cetera, but he wasn't actually making a contribution to that. So that is the sort of two narratives that are competing right now before the special court. And so all of those cases have been now submitted to the court, and we'll have to see where the judgment comes out. It's also taking some cases on against other individuals who are being accused of interfering with witnesses and attempting to bribe, essentially, prosecution witnesses. So those contempt proceedings are also going forward. And those will then be heard by a residual mechanism that will be dedicated to that particular tribunal. One of the accused, interestingly, in these contempt proceedings has gone state's witness. He's essentially pled guilty and has agreed to help the prosecution in exchange for some leniency. So it will be interesting to see what we hear about his co-accused in these contempt proceedings. So, Special Tribunal for Lebanon, established in the wake of the 2005 assassination of the Prime Minister Rafiq Hariri, who really was, in many respects, an incredible figure process going. As the negotiations evolved, and especially at Rome, there were certain elements of the ICC statute that the U.S. was very concerned about. The one was the idea of an independent prosecutor, a prosecutor who can choose which situations to bring on his or her own. And the second was these jurisdictional preconditions, the idea that not only would jurisdiction be premised on the territorial state being a member, but also on the nationality state. And because we have so many troop commitments and so many troops out in the field in areas doing humanitarian work and doing other work that's more controversial, the Iraqi invasion, for example, we were going to be particularly vulnerable. Our troops were going to be particularly vulnerable to ICC jurisdiction because we're on the territory of states that would eventually, it was assumed, join the court. And I think the real concern with the U.S. is not so much that that someone is going to be charged